Hello friends, welcome to V.S.P.Law channel. Thank you for clicking this video. Today topic is that plaint and WS. What is the meaning of plaint? When we are going to file the plaint? What procedure for filing the plaint? And next to WS, what is the meaning of WS? When we are going to file the WS? What steps is needed to file WS? Then these are the topics. These are the points we are going to discuss. Friends, if you like, you can maybe give a support by like my videos and share, subscribe. Please forward to your friends by way of the social media friends. Thank you for watching once again. Come to the topic. Plaint. Generally, so plaint is a P-L-A-I-N-T, plaint. So this term is used in civil cases only. When the party is going to file a civil case against another person who caused a damage to property or rights. So the party here called plaintiff. To whom is going to file the case, file the civil case, the party is known as the defendants. Clear? Plaintiff and defendants. So here is the party is the plaintiff. Plaintiff is going to file the suit. Suit means case. So in civil cases, the first step of the filing the case is that prepare the plaint. So how to prepare the plaint, friends? So keenly observe and listen that the top of the plaint means as a document like an application, like a petition only. But they have the clear, not only one document, there is a number of pages are there. A set of pages is a plaint. So come to the first paragraph. The plaint is the court name, friends, and the court name means in the court of the court of the Honorable Prince Senior Civil Judge, like that, and place of the court, and so number. If it is civil cases, you know that land cases original suit OS, like that, OP OS only. So next between parties, you have to mention the parties names only. Name of the plaintiff X, like that, plaintiff, and Y different, like that. Only name of the parties. And next, subject matter, friends. You have to mention the subject matter, means which relief you want from the civil court. You have to mention that. For example, if you want a permanent injunction, you have to mention that suit for permanent injunction in survey number, in situated in so and so places. You have to mention the subject. Then you have to mention the provision. Generally, in civil cases, all plaints are under section 26 of C.P.C, Civil Procedure Code, read with Order 7, Rule 1 of the C.P.C. This provision applicable. And next to that, this is the stepwise. You have to observe that. The first step is that description of the plaintiff, friends. You already know that plaintiff. So name of the plaintiff, son of the plaintiff, and age, occupation, and residence of the plaintiff. If the plaintiff is one, you have to mention solo plaintiff, and if it is a number of plaintiffs, you have to mention plaintiff 1, plaintiff 2, plaintiff 3, like that. And next line, you have to mention the name of the advocate, stand for the plaintiff, for communication, correspondence, like summon, sign, notice, whatever it be. And this is the description of plaintiff. Next, step 2, here is the description of the defendant. under which you have to mention the name of the defendant and son of, so the same way, son of, age, occupation and residence, if it is data is available. Okay. Next, it must be mentioned, not the party, those who are going to file the case, he has to get the details of the defendant, must needed. And after mentioning the clear details of the defendant, you have to mention in one paragraph that summons or service is, you have to put as empty. So why? Because we don't know the other party counsel, advocate. And next, third step is the brief facts of the plaint. So this is a very important step. We have to observe and keenly follow the case. Before the making the brief facts, you have to observe the legal notice. Already we discussed legal notice. So before filing case, legal notice issued by the plaintiff. So as per legal notice and as per evidence that are available on behalf of the plaintiff, and also remaining documents. So basing on the relevant document and registered original documents and proof of the documents, you have to prepare the brief facts, and as well as you have to take the feedback from the plaintiff. So first brief fact, under brief facts, first paragraph, introduction of the ownership of the property, and maybe second paragraph you have to mention the when the ownership is confirmed and under which category the ownership is allotted, and what are the original documents are there, and whether the owner name is recorded in revenue records or not, whether the plaintiff is in position absolutely as absolute owner of the suit land is, and also position, you have to mention the position of the land, since when the position is in custody in the hands of the plaintiff, you have to mention that clearly. Position is required, friends. If it is position certificate is available, it is better to file as a proof. So this is a brief facts clearly mentioned, and cause of action you clearly mentioned. And next is the cause of action. Clear. In under cause of action, so when the accident means when the incident is taken place between the plaintiff and defendant, the date of the incident, and when the legal notice issued, the date must be mentioned. So a reply notice, date of the reply notice, these are the dates for incident you have to take as a cause of action. Cause of action must be needed to prove the case. So you have to take the clear steps. And next one, limitation. The case is filed within the limitation. You have to mention that. It means after incident, you have to immediately file the civil case. If it is time barred, then the suit will be dismissed on time barred basis. Remember, friends. And jurisdiction, you know very well jurisdiction is so where the place there is a jurisdiction, you know that, already told. So then you have to mention the jurisdiction. And valuation, this is very important. Valuation, calculation of the court fees on the base of the market value which is issued by the registrar, sub-registrar of the property, sub-registrar of the place, which property is situated. So that market value, court fees on base of the market value. And next paragraph you have to complete. Last of the paragraph is the prayer. What relief you want, you have to mention that. If it is permanent injury, you have to mention what it may be. Prayed the honorable court may be decree the permanent injection, like that. If it is another relief, you have to mention another reliefs. After that, put the signature as a plaintiff, and declaration, declare the contents of the plaint, and you have to mention, you have to make the signature, and it is verified by another advocate. After your counsel will make a signature, and then after list of documents means proof of the documents. This is sale deed, market value, and pahanis, etc., etc. What document, original documents you must be filed. Some persons, a list of document may be separated as mentioned in the plaint, a separate copy for list of document, mentioning like that only. But some persons clearly mention the list of documents. Okay, friends. And then schedule. Schedule means here is the property details, boundaries of the properties. North, south, west, east, like that. And you may be attach a affidavit. Section 26 subpart 2 of C.P.C. affidavit means plaintiff name, details of the plaintiff, cause title, details of plaintiff, and I'm filing so and so suit, and what are the contents mentioned in the plaint that are true and best of my knowledge, that is the affidavit given by the plaintiff as a deponent. And this is the plaint. So preparing the plaint is a very important in civil cases. The case, winning of the case mainly depending on the plaint only, and then after documents, true original document and genuine documents, remember. So this is the plaint. And come to the WS. Second topic is the WS. What is the meaning of WS? WS means a statement written by the defendant. It's called WS. Means version of the opposite party. Version of the opposite party in civil cases called WS. Simply, so when the WS is can rise. So listen. After filing the civil case plaint by the plaintiff has to send a copies of it, means plaint documents, to the defendants through the process. And after receiving the documents, defendant is going to give the reply, means his version of reply by filing the WS. After receiving summons, here summons means notice, like notice. After receiving the summons from the court, defendant can engage advocate. Through the advocate, he can file the WS, written statement means his version. What contents in the written statement, friends? Written statements only same cause title, and after that a written statement of the defendant D1, D2, D3. So you have to mention that. And here is that as per plaint you have to first of all deny the paragraph of the plaintiff generally, and then after mentioning the true facts of the defendant version. So that is the written statement filed by the defendant through his advocate. So after filing the wakalat, then there is a time bound is there. 90 days he has to file the written statement. Defendant file the written statement through the advocate. So that before filing the WS, a copy of it given to other counsel for the plaintiff. So after filing WS, then the both parties means plaintiff defendant come on record. Then trial will be started. This is the WS. So in this session we learned plaint and WS. I hope you will get some satisfaction by observing this video. So if you are satisfied, you can give the like and share, subscribe, and click the bell icon, friends. Please forward to your friends by social media. Please support. Thank you for watching. Thank you one and all. Thank you, friends.